My name is Howard Klebanoff, and I am an attorney with the firm of Klebanoff and Alfano in West Hartford. Today, September 14th, 2004, I have the distinct pleasure of continuing our interview of attorney Catherine Roraback. Catherine, at our last interview, you were discussing several of the various individuals and attorneys, many of whom gave you guidance and help in your early years. Was there specifically another attorney involving a certain case that gave you certain advice that shaped ultimately your thoughts and feelings about the types of cases you took?
Yes, it was Tom Robinson, who was the public defender in New Haven County, an old friend of my uncle's, and one with whom I spoke on numerous occasions. But in any event, early on in my career, I would say the first or second year of practice, a black man had been arrested in New Haven, charged with having kidnapped and assaulted, raped a nurse at the Yale New Haven Hospital. And his wife came to see me and asked if I would represent him. And I really felt that I couldn't handle a rape case, that I just, as a woman, as the woman I was at that time, I could not deal with it. And therefore, I called up Tom and asked him if he would represent this man. And he said to have his wife come over to see him, and she did, and he did take the case and defended the gentleman. But when he was finished, he called me up to tell me that the case was concluded, but he wanted me to come see him, and I went over to his office, and he gave me this lecture. Said to me, you know, Catherine, if you're going to practice law, you have to take any case that's presented to you. I mean, that's one of your obligations as a lawyer. You do not take a case because you feel diffident about it or bothered by the facts and so forth. And, you know, I understand why you did this, but you should never do it again. And I always remembered Tom for that, because it certainly changed the way I approached the law. And here I am today.
Now, over the years, you evolved into a very distinguished trial lawyer with heavy emphasis on civil rights and criminal law. My recollection of the period, particularly from my own experience, even in the 60s and 70s as a young attorney, is that trial law was really the bastion of the male lawyer, almost part of the old boys network. What led you into this area?
It's hard to answer that, Howie. I've talked about my background and my relationship to my uncle, who was a great trial lawyer. And I'd gone to court with him on many occasions. I really thought it was part of the practice of law, and that if you were a lawyer, among other things, you'd try cases. And from the start, I just assumed that that's what I wanted to do. And it didn't seem strange to me at the time, which in retrospect seems peculiar, I know. But it didn't seem strange. It was just part of being a lawyer. And if I was going to be a lawyer, I also tried cases.
Do you think you encountered many more obstacles in trying to enter this area? Because even from your own description, as you described your interviews with different law firms, women, unfortunately, were slotted into different positions, almost sort of the back room sort of position, so to speak. Yet here you are actively out there working on a day-to-day basis with many colleagues, all of whom are male, in this so-called male bastion area.
Yeah. Well, I think part of it was the support Harry Lander gave me. He just assumed that I would go to court and that I would handle matters. I've always felt that having been a Roraback was a huge advantage for me. It was not as though Jane Jones walked into a courtroom, but if you're a Roraback and with the family reputation for being trial lawyers, I mean, I have cousins in Torrington who were also, Charlie Roraback was a very well-known trial lawyer in Litchfield County. And the bar of the state was a very small bar. I mean, everybody knew each other, some better than others, depending on which county, but certainly it was a small bar. And I think I was accepted partly as a Roraback, as sort of an odd phenomenon, shall we say, that here was a woman in the courtroom. I talked about that first day at Short Calendar in Common Pleas Court. You know, I was something that stood out as rather unusual, but people were very, you know, I became accepted rather fast on.
Now, in looking at your career, it's, to me, an amazing one, and it almost mirrors many of the events in our society, particularly over the 50s, 60s, and 70s. What I'd like to do is to go into some of the key cases or the cases which you feel had an important effect on you or on society. I'd like to start possibly with the Smith Act cases, and if you could describe your role in those cases.
Well, the Smith Act cases, number one, this is at the height of what was known as McCarthyism, 1954, when the arrests occurred. Communist Party leaders in Connecticut were arrested on charges of conspiring to overthrow the government by force and violence, or conspiring to advocate, I'm sorry, not the overthrow, but conspiring to advocate the overthrow, which put two levels of speech into everything. There was never an overt act that was anything more than speech in any of those cases that I know of. So my role was, I was one of the defense lawyers. Now, I was one of two original defense lawyers, three of us, Marvin Karpatkin, who at that time practiced in New Britain, and Sam Gruber, who was a lawyer in Stamford, did labor law. We were all three of us were members of the Lawyers Guild, I guess, which was considered to be a rather radical organization. But all three of us had been retained directly by the Communist Party in that situation, or by the clients who were Communist Party members, leaders. Sam could not continue in the case, but for very personal family reasons. But so we were trying to get additional lawyers, and we applied to the court to appoint them. First, we went around interviewing and trying to get lawyers to agree to serve. We hadn't been successful, and the state bar intervened and said that they would, if the court appointed lawyers, that the state bar would pay them and raise the cash for that, as I understand it. At least I believe that was the case. In those days, if you were a court-appointed lawyer I think in either the state or federal court, but this is a federal court proceeding, there was no pay for it. And sometimes that court appointment was used in punitive ways. But in this case, Judge Anderson appointed a number of lawyers to participate in it. As one of the original lawyers, however, I don't think the other lawyers came in on the pretrial motions to any extent. We handled things such as the challenge to the jury system that I spoke of, the motion to dismiss on the ground on First Amendment grounds that this was a speech case, not that they shouldn't be prosecuted for pure speech. But after those motions had been disposed of, and there were others that were far more complex, but we don't have to get, they all formed a great foundation for the appeal that occurred at the end of it. We then had the trial, which itself took about 6 months. And at that time, these other attorneys were part of the defense as well. That case was really an education for me because it was the first major case I'd done. Prior to that, I'd handled a number of minor things, semi-minor things, breach of peace, drunken driving cases, you name it. I had the good fortune to learn on cases that weren't going to affect someone's life or just, long-term sentences involved. But I had never done, for instance, a pre-trial at the beginning of the case, getting up and telling the jury where we were going. That was just not part of what I'd had experience with. And so it was partly a learning experience. It was also, during that period, interestingly, if you know any of the history of international communism, there was something, it was a special international meeting at which Khrushchev, or had not Khrushchev, gosh, I'm getting out of my speed. Anyway, the Communist Party became split over the doctrine, and here were these defendants in the courtroom trying to defend themselves with a whole public discussion going as to what basic communist doctrine was and so forth. And it was a very trying period for all of them, right at the time we were presenting the case.
Now, in trying a case like this, did you have any reluctance in getting involved in a case like this initially?
Actually, I wasn't reluctant. I knew it was a tough case to get involved in. When the arrests occurred, my name was on the radio, and it's not a name that disappears easily. My uncle in Canaan called, and he was very upset. He wanted to see me. I went up to see him. He wanted to know why I'd gotten involved. And I remember saying to him, he was a great criminal lawyer, I said, well, if a woman came in your office and said, my husband has been arrested, will you represent him? What would you do? And that was sort of the end of the conversation. But his concern was that I was ruining any possibility of a career.
I was going to ask you the effect, if any, that you were able to measure on clients, potential clients, or the attitudes even of other attorneys in the bar towards you at that time.
Well, actually, I do remember very vividly that in the city of New Haven, there were only about 6 lawyers who spoke to me for about 2 years. I mean, this is other than the defense lawyers I was dealing with every day, but there were only about 6 who spoke to me. I always remember with great affection Max Schwartz, who was a trial lawyer in New Haven, did a lot of domestic stuff. Max took me to lunch one day, and I've remembered it all these years because it was the only time I had lunch with someone outside that little coterie of trial lawyers.
During that time period in the 50s of the Big Red Scare, do you feel many of them were afraid of possibly being accused of potentially having leanings towards the Communist Party or
Oh,
something?
yeah. No. Interestingly, though, the State Bar Association, the ABA, would pass a resolution every year at their annual meeting talking about disbarring communist lawyers, etc. And this would be referred to the State Bar for action by the state bars. Alan Brown was president one year, and it was during this period of the Smith Act cases, as I remember it. Alan appointed me to a committee of the State Bar to consider what the State Bar should do with one of the resolutions. And the committee was very cordial to me. I mean, there were several members whom I remember still. And the State Bar decided not to adopt it. Actually, the State Bar never adopted one of those resolutions, but it was obviously aimed at lawyers such as myself.
Right. Now, during this time also, I believe you were becoming involved in various civic activities or with various groups, the NAACP or eventually the Women's Caucus. Can you describe a little about that era?
Well, that era, it began when I was first out of law school. I joined the NAACP, and I used to attend meetings, and I would do things for them, such as doing affidavits for people who had trouble with the police, had complaints about the police. But it was still a very segregated society we were living in. Before I'd gone to Yale, I was living in Washington, D.C., which was such a segregated city that the government cafeterias were segregated. Post-World War II, a number of black soldiers came home having served abroad and had to face returning to what was a very discriminatory society, if not totally segregated. And so I was active in the NAACP. I also, at the same time, there was a riot that occurred at a Paul Robeson concert in Peekskill, New York, and several young doctors from the medical school, they were residents or interns, I can't remember which, had been down at Peekskill, and one of them was very seriously injured as they were driving out of this parking area. Rocks were thrown at the car, and his face, his whole side of his face had been hit by a rock and glass. And so this group had meetings, wanted to form a civil liberties committee, and I participated in those meetings, and we formed what eventually became the New Haven Civil Liberties Union, and then the state Connecticut Civil Liberties Union. And I eventually ended up on the national board of the ACLU. So that was sort of, that also came out of that period.
Now, did these activities shape many of the cases you were retained on or lead many clients to come to you because of your commitment or involvement in these?
Yeah, I'm sure that's why the Communist Party came to me. I was also involved in the Progressive Party in '48, but the part of, there's a double thing here. As a woman, I wasn't getting a great number of cases. I mean, if a man got arrested, he wouldn't think to come to a woman who, unless he happened to be Harry's client, was referred to me. But I wasn't building a great. But obviously, someone of who was involved in something like the Smith Act case or other near cases That's not the sort of person that most lawyers would take on.
Right.
I mean, the criminal bar was not a civil liberties bar, let's put it that way. And so I was there, you see. I was there. I didn't have cases. I had the time, and so I got them.
Well, you may be playing down your reputation a little, but it's an interesting evolution.
Yeah.
Let's go into some of your other cases that you'd like to discuss with us while we're here. Certainly, there's the Griswold case.
Yes. Well, actually, the Griswold case came to me in part because of the Smith Act case. There was a professor at the Yale Law School, Fowler Harper, who was a great civil libertarian. And Fowler was also taught domestic relations law, family law. He was consulted by Estelle Griswold. Well, I should put it differently. Let's go back to Lee Buxton, a doctor, came to New Haven to head the OBGYN unit at Yale. And he was a nationally famous specialist in his field. He was enlisted by Estelle Griswold, who was the executive director of Planned Parenthood, to go to a hearing on a repeal of this statute that we had in Connecticut, which prohibited the use of contraceptives. And Lee went to that hearing and discovered, I mean, you've seen what goes on in some of the abortion hearings of more recent times. They were mild compared to what the hearings were where there was a statute to repeal this prohibition on the use of contraceptives. I mean,
These were legislative hearings.
Legislative hearings up here in Hartford. Anyway, Lee came out of this totally shocked. He was a very proper gentleman, and he just had never been treated the way he was treated in these hearings. And he wanted to do something about the statute, and obviously he can't get it repealed under these circumstances. He and Estelle were discussing it, and so Estelle got Fowler Harper to come to a cocktail party at her house. I've always said that it was her martinis, which are were some of the strongest that you've ever seen. Probably was the beginning of the Griswold case, but in any event, she introduced Lee to Fowler, and the two of them discussed what could be done about this. That's background, because Fowler was not a member of the Connecticut bar, and his plan was to start a series of declaratory judgment actions to have this statute declared unconstitutional. And he called me up and asked me, said that he thought that I deserved to get a good case since I'd done this Smith Act trial, and so I actually got the Griswold case because I had done the Smith Act trials. An interesting bit of history. In any event, I agreed to do it, and we did this series of cases of various couples who one had malformed children, another had an RH blood factor which threatened any child that might be born. And the most serious was this really wonderful woman I got to know, who was who had a stroke during a pregnancy, had to carry this fetus to term, even though everyone knew it would not survive the pregnancy because she would be unable to deliver it. And Lee Buxton was convinced that she would die if she became pregnant. our thought in all these cases was that we would never get the statute itself declared unconstitutional. And this was a sort of a premise that it was an impossibility in the considering the state of attitude at that point toward these cases. But perhaps we would be able to get the court to interpret the statute in such a way as to enable Lee to prescribe contraceptives for a woman in that condition. I'm talking about Jane Doe now. The cases went up. The Connecticut Supreme Court did not read the exception into the statute. They held the statute constitutional. It went to the U.S. Supreme Court. And there, in the arguments, Justice Frankfurter finally wrote the opinion, but it was held that these cases were not really real cases, that the statute had never been enforced, and that therefore, or was never enforced, and therefore the lawsuits were frivolous.
Now, did you handle the case up to the Supreme Court?
Yes, Fowler argued it in the Supreme Court and did the brief and argued it. And so we were faced with this finding. Now, the fact of the matter is that there had been a case in the late 30s, the Nelson case, which found the statute constitutional in the Connecticut Supreme Court. That had gone up on a certification of the issue from the trial court, and it went back to the Superior Court, where at that point, as it was worked out, the prosecutor nollied the charges, and Planned Parenthood, whose clinic this had been in the Nelson case, Planned Parenthood closed all the birth control clinics they had in the state. There were 6 of them at the time. And there had been subsequent attempts to challenge the case, but what Frankfurter never understood or never accepted was the fact that although private doctors did in fact prescribe to private patients birth control, etc., no doctor could function a clinic, so it was poor women who were denied birth control, not the upper classes, shall we say. And Planned Parenthood had provided that service. So that there was this desire to open a clinic in Connecticut, and that was what Estelle Griswold, now for the 15 years after the Nelson case, what Planned Parenthood in Connecticut did was to provide transportation to women to go either to Rhode Island or New York, where there were functioning clinics to get birth control. But there was none provided in Connecticut. And so when Estelle Griswold became executive director of Planned Parenthood, what she wanted to do was to bring birth control to Connecticut in clinics. And when we had this decision in what was the Poe v. Ullman case, it said that the statute wasn't enforced. The decision was, and I say this very clearly because it's the publicity or what the history that some people have written is incorrect on this score. The real decision was, if we can have a clinic, we'll have one. And if Frankfurter's wrong, we will go up to the Supreme Court to test it. It wasn't that the clinic was opened to get an arrest, but if it happened, we were facing what would go on. And there was very careful planning of what that clinic would be like. Only married people were to be served. or that was what I thought was being planned. It turned out when the actual forms came out, there was nothing that limited it to married people, but in point of fact, the only people who had gone to the clinic up to the first 10 days or 2 weeks before the arrests were married.
Now, with all the strategy and planning that went on, and this must have evolved over, I mean, you were involved with this case for years.
It was 58 to 65.
Was there thought given to sort of the legal premise? In other words, were you going to challenge it the second time around on the constitutionality of the statute or on the right to privacy?
No, the right to privacy became introduced right at the end of the Povey-Ullman, when the decisions on Povey-Ullman came down. Our challenge up to that point had been due process. In Lee Buxton's case, the right of a professional to practice his profession according to its highest standards. Other due process questions for married people. It was sort of premised a bit on privacy, but it was never verbalized as privacy. At the same time that we were doing the Povey-Ullman case, the privacy issue was hot in our society. This was the end of the 50s when you'd had this expansion of the FBI, the intrusions on people's lives, the police seizures of materials,
Right.
And the day that Povey-Ullman was decided, Mapp versus Ohio was decided, one of the most important search and seizure cases in our history, and that was done on a privacy decision. So you had that whole context of the court operating in the context of privacy. And two of the dissenting opinions in the Povey-Ullman, one was by Justice Douglas and one was by Justice Harlan, raised the privacy issue in the, that's the reason that we should have, won in Povey-Ullman. So needless to say, once we began the Griswold defense, because the clinic was closed by the police, privacy became a part of our discussion right from the beginning.
What was the effect of your ultimate victory in this case, again, on your practice and on your career?
Well, I remember I almost quit the practice of law because I knew that nothing would seem so good again. You can't win a case like that and not think that you can never repeat yourself. But one of the things that happened was that I'm trying to remember, this is 65. I'd certainly, by that time, I was well established, let's put it that way. My career was there. I had argued a number of other matters prior to that, and I was sort of known within the bar for doing civil liberties and some cases, but it was just about that period that you also had the what I think of as the renaissance of the feminist movement. Some people think that it was founded in the 60s, but there were feminists around for a lot of years before some of the current names appeared on the scene, and so you became conscious of that. Now, there were obviously, during the whole Griswold litigation, Lee Buxton was constantly at me because the premise of, and you'll see it in the decision, the premise was that this was a right of married people to privacy. It was marital privacy. And Lee kept wanting to push it beyond that. I mean, his first thing was always that poor women didn't have care. We were in the Connecticut Supreme Court when I was arguing Griswold, and Lee was one of these clients who came to court all the time. He was a wonderful sense of moral support. You always knew that you had a cheering section in back of you, just about. Anyway, Lee was there, and when we finished the argument, and the court disappeared before those doors up there above the bench, he came forward. I mean, it was the end of court session, so he came through the gates and came up to me and is saying, great argument, you know, and he said, but, and I said, I know, Lee. I said, I'll get to poor women later. And he said, it's not the poor women I'm talking about, it's the unmarried teenager. And he said it in his most ebullient noise.
This was in the 60s?
In the Supreme Court chambers. I never knew how close or far the court was from those doors. I was ready to go through the floor, I can tell you.
Catherine, while you were involved in these cases, certainly they had to occupy a phenomenal amount of your time. Were you able to continue general practice?
Oh, yeah.
Handling the general type practice case, divorce, and...
I had divorces. I was doing... By this time, I was having an office in Canaan as well, because my uncle had died in '55, and the old family office was there, which I inherited. He had had an active practice, and I also had family commitments in Canaan that I had to attend to. So I began spending time in Canaan, and I was doing, you know, a very general small town practice, including a lot of small criminal cases, et cetera, in Canaan. And I just never really broke that tradition. I still practice in that office.
The same office?
Yes, I was practicing in both Canaan and New Haven. And actually, I used to say I made my living in Canaan and I had my fun in New Haven, but it was not quite true but I was doing a lot of general things, and I was doing general things in New Haven too, divorces and.
Now, these cases that you had just described obviously had an effect on your reputation and on you personally, but I believe in some of our discussions you mentioned a divorce case, which had a profound effect on you as you represented a woman.
Well, yes. Actually, I've been very conscious of this before, but there were a number of divorce cases in which women who were in their 40s or 50s were being sloughed off, shall we say, by their husbands, and or were finding that their marriages were just impossible. And I had handled some of these. I mean, and when you start from a woman's perspective, these cases could be really frustrating. The assumption of most of the male bar was that if you're representing a woman, she has no right to the assets that were accumulated with the husband's earnings. You see that the husband was the breadwinner, and therefore, when you had a property settlement, he got the property. And the only point at which you could even argue to the contrary is that he had some obligations to his children. But this concept that the wife's contribution to that marriage, and in those days, I mean, I'm talking now about women who were not out working in the workforce, but being homebodies, shall we say.
Talking in the 50s and early 60s.
60s, yes. Anyway, that wasn't quite the case with this particular case, but I do remember arguing with somebody from Robinson and Cole, one of the senior partners there, about whether a wife deserved to have an allowance for having been, done the dishes and cooked the meals, taken care of the children. And every time he would argue that his client deserved the house, I would come back with some figure I would put on what her services had been worth for 20 years or so.
Which
anyway.
was not an accepted theory at that time by any
No.
means.
No, it's actually it still is not accepted in some families. I must say that the law has progressed a bit. But quite apart from that, one day I had this is up in Canaan. I had a call from a woman whom I didn't know, asked for an appointment. And when I called her back, I looked at the last name and I looked it up in the phone book just to see if I knew them. And her husband was a lawyer in the area. And she was the daughter of a lawyer whom I'd met during the Smith Act trial who'd come to court. He was a Boston lawyer who had retired from practice. He was an old Brahmin. And he had returned to represent people during the 50s in loyalty proceedings, etc. As an old-time civil libertarian, and the best tradition of the bar. Sort of the Joseph Welch tradition. Anyway, wonderful man. And he had told his daughter to come see me, so she came in to see me, and she kept saying, well, you probably won't want to talk to me because, my husband's a lawyer, and you know him, and it'll be, I said, don't be absurd, if your father wants me to represent you or give you advice, I'm quite willing to do it. But she was totally, this is a woman in her, let me see, I can precisely say, I would say she was in her 50s, yeah. She's 10 years older than I, no, less than 10, but close. In any event, she was scared to leave the home because it was a very unpleasant family situation for her. She was scared to leave the home because she might lose her children if she did. And she was worried about starting an action where, she had the feeling that she had no sense of her own worth in this marital situation. She just knew it was, and her father, luckily, was urging her to get out of this thing. Anyway, I represented her. I brought the divorce case. I had to reassure her all the time that she wasn't going to lose the children. And I must say that I wasn't totally sure of that, knowing the way the courts were in those days. I may say that this husband really didn't care about his two daughters. He was just worried that he would lose his son, and that she shouldn't have custody of this boy. We went through, I think, 4 to 5 years of litigation. But the first year, it was the father had good friends and his own, who ran a woman's finishing school, ladies' finishing school in Europe. And he had arranged for his daughter to get a job at that school. And his idea was that she would leave the home. The girls by this time were in boarding schools, so they weren't involved in day-to-day worries, and that she could take her son with her to Europe. And the husband was threatening to have her arrested if she did so. And I started this divorce action and was asking for custody, and it became finally she did go to Europe. She did have the boy with her there for a year, and she came back and got a job in New York and worked in New York. And we went through this long period. The husband finally countersued on desertion grounds, since it was more than 3 years. This is back in the days when you really had to prove a case. Yes. Divorce cases were not the simple things we have now. You had to prove fault, etc. And eventually, one day she called me from New York. She said, "Catherine, I've met the most marvelous man." And I remember at the time saying, "Don't tell me a word. I have to stay self-righteous in court." So, but the day the divorce finally went through, I went to New York and had drinks with her and her soon husband-to-be, who was indeed a very fascinating, well-known newsman. And she married him, and they had a wonderful marriage, and she became a very good friend, and she blossomed forth. I mean, during this period, she had gained all of the self-confidence that you would hope that every woman should have.
So instead of being battered down by the divorce, you saw her grow and become...
So I saw her liberated and become what she should have been a long time ago. And I mean, she certainly had all of it there, but I watched it blossom, and it was just a very exciting and very rewarding thing.
Knowing that you had contributed to her liberation.
Yeah.
Now, during the 60s, certainly we had our turbulent years also regarding various protests, demonstrations, issues of the war, conscientious objectors, protests, and demonstrations also regarding civil rights, all of which, I know you were involved in and representing different clients, and I'd like us to kind of get into a discussion of some of those cases before we concentrate on maybe the Black Panther case in particular.
Sure. Well, there was a period of on the Vietnam War. I certainly did a number of CO cases, conscientious objector cases. And as a matter of fact, I made some law in the Second Circuit on that subject. So there was sort of, and I'm talking about a number. I suppose I probably represented at least 20 or more of those cases. I did one for a fellow who had enlisted, and then when faced with reality, became a CO. And I actually tried a court-martial case, not successfully, I may say, but...
In some of these cases, not only in the 60s, the various protests, whether it be about the war or civil rights, but even in the other cases you discussed, did you find that the judges were neutral, so to speak, and tolerant of your position, or did you find you were really dealing with judges who had their own bias and philosophies and treated you with some disdain or hostility even?
Hostility, but not disdain. I mean, it was, they were fights.
So you had that additional hurdle to overcome in dealing with them.
I mean, those were not happy cases, let's put them that way. But that wasn't true necessarily of the CO cases. I mean, there you had I remember trying a case before Judge Blumenthal here in Hartford, and the prosecution, to prove a CO case, had to prove that the person had made the application, was classified 1A by the draft board and refused induction, so you had to produce somebody from the induction center to prove the refusal to serve. And in this particular case, and I must say that I thought it was a pretty weak CO claim, and I wasn't sure that I was going to win this one. They'd gone through the draft board's materials, and the classification 1A, and then the prosecution rested, or said, we have no further evidence at this time. Never used the word rest. And I got up, and I remember Blumenthal looking down at me with that wonderful grin of his and saying, "Yes, Ms. Roraback." And I said, "Do I understand the prosecution is resting?" And the prosecutors tried to say, "Oh, we have no further evidence." And finally, I said, "If Your Honor, please, he finally compelled him to say he rested. Well, I guess he asked him. At some point, we discovered that the problem of the case for the prosecutor was that he didn't have anybody from the draft board to testify because they had drafted the draft board person to go off to Vietnam, and he was somewhere in Vietnam. So the case got dismissed, but I'll never forget that grin, and obviously Blumenthal thought it was funnier than anyone. So, it wasn't all opposition. But the other cases, there was a demonstration against the Vietnam War in New Haven. It was a march from the Yale campus to the Selective Service headquarters, and I always remembered that one because by this time I'd had a lot of experience with the New Haven Police Department, who had a special services division, and when I saw the pictures of that march, a couple of the marchers were in fact members of the New Haven Police Department who were there not to demonstrate, I must say, but they had become part of it. I mean, and then later on there was a demonstration in Hartford, which you remember. We tried it together at the welfare department, and this was black demonstrators who were claiming that the welfare system should be changed, somewhat improved. But there again, I recognized some of the same people from the New Haven Police Department in the hallway of that building where the demonstration occurred in Hartford.
I'm going to have to ask you a question about that case, Catherine. I was a young attorney getting started in Hartford and got involved in what was really my first criminal case with civil rights overtones. And you were just incredibly gracious. You submitted to me copies of motions you filed, pleadings, briefs. At many of the court proceedings, you took the lead. And the amount of comfort you gave me, and I know this is true of many other attorneys throughout the state over your years who have also commented on this. Was this something that was part of your nature? Was it based on your experiences as you got started as a young woman attorney, sort of alone in the courtroom?
I don't know the answer. Until people tell me these things, I wasn't conscious of it at the time.
You were incredibly helpful, I know, to me and to many other lawyers, and you certainly set a standard of competence and excellence for all of us to try to emulate and follow. As we proceed then, certainly a case that received national notoriety was the so-called Black Panther case in New Haven. I'd like you to describe that to us, if you would. Through a lot of matters very well. Catherine, could you describe or give us an overview of the Black Panther case?
In a brief 2 minutes.
In a brief.
That was only 2 years of my life, but I'll try. The Black Panthers were an organization that was formed roughly in the late 60s. First in Oakland, California, by Bobby Seale and Huey Newton, to assert black rights in their own community, sort of self-protection theory. It became extremely militant. But it had various programs. One of them, quite seriously, was providing lunches or food for school children. There was the encouraging schools, etc. Now in 1969, the end of 68, John Huggins, who came from New Haven, was in Los Angeles at UCLA, I believe, and he was married to a young woman named Erica, who was Erica Huggins, who became my client later. I'm just getting the background in. John was killed in a shootout in LA with an organization called USA. It had a chief named Katanga, and was later shown to be, in fact, an organization somewhat sponsored or financed by the CIA. And they had picked this fight with the Panthers, and both sides were shooting. John was killed. After that, Erica came to New Haven because John came from New Haven. He was of a family here in New Haven who, and I had represented John before in that same demonstration, welfare demonstration case we talked about earlier. He had been a young man who was in college at the time that he got involved in the welfare demonstration. And then he had, after that case those charges were completed, he was on probation, but went to California and was at school there. So Erica returned with their child, who at the time her father was killed was, I believe, if I remember correctly, 24 days old, but a very, very small child. And she lived in New Haven with the Huggins family for a time, and then a chapter of the Panthers was formed. And they had a house in New Haven, and Erica moved to that house. But she was still seeing the Huggins family, probably daily, but also being active in the Panthers. And there was a meeting of the Panthers on the streets of New Haven in the spring, I remember, probably May Day, and that was where I first met her. I went up and spoke to her since I'd known John, and she had made a very flaming speech, I may say. She was an orator, maybe still is. I mean, she's still with us on the coast. In any event, someone was brought from New York, I mean, from a Panther group in New York, and this man came up and brought with him someone they claimed was an informer, or he claimed. His name was, he was George Sams, who brought this young man up with him. His name was Alex Rackley, and Rackley was held at the Panther House for approximately a week or two. And then Sams and Lonnie McLucas and Warren Kimbrough took him from the house. They drove to Middlefield and killed him at night in a swampy area, as I remember it. And the police then arrested everyone who lived in this Panther house. There were about 8 of them, as I remembered. I can't remember numbers anymore. But among them, Erica was, and they were charged with kidnapping, assault, murder, conspiracy, everything. And at the time they made these arrests, they spent 4 days searching the house and seizing everything in the house. So I was retained to represent Erica. Eventually, I also represented 3 other women. There were 4 women altogether who were arrested. But these cases were tried separately, and I eventually tried the case. Erica Huggins and Bobby Seale were tried together, the sort of the final cases of the thing. And that trial occurred in the beginning in the winter of 70-71, and the jury came in at the end of May, so that trial went on. We spent actually, I guess my memory is it was 5 months, but that's probably an exaggeration. Maybe it was 2 months on jury selection. Before all of that, we'd done a series of court hearings, motion to suppress, a motion to set bail because they were being held without bail. We were unsuccessful in getting them out on bond, so in this 2 years that went on from the time of the arrest to the time of final determination, Erica was in prison for 2 years during that period.
I'm going to go back for a minute to the case, but what was the final disposition of the case?
It was, we had a hung jury, and in many ways it was, I mean, if we know the personalities, I should say that the judge dismissed the charges on the ground that we couldn't get a fair trial if there was a retrial.
Who was the judge in that case?
Judge Mulvey, Harold Mulvey. In the course of the trial, I was representing Erica. A man named Charles Gary was representing Bobby Seale. And David Rosen in New Haven was assisting Charlie. He had to have a Connecticut lawyer there with him, and I had arranged to have him come in to be with Charlie. But Charlie Gary was an old-time male chauvinist. I mean, a good sense of humor. He was always cordial to women. But Charlie had grown up in a different era than well, a different world. We were about the same age, I guess. And Charlie could never understand how I could represent Erica. How I could create a defense for her. Because his idea of defending a woman, which was very common in those days, was that you treated her as a poor young thing. She was led astray by these, terrible people that she didn't know what she was doing, and please be sorry for her and dismiss the charges, sort of thing. That was Charlie's concept of a defense for a woman. And I kept explaining to him that it just wouldn't take with a woman like Erica. She was a very, very strong person. And they had some evidence which was pretty horrendous too. There was George Sams had arranged for an interrogation of Alex Rackley so they would have a tape of this trial of Alex Rackley before they killed him.
This was a trial the Panthers had?
Yes, in the basement of the Panther house. And George Sams had Erica conduct that interrogation. And this is when I was beginning to change my non-feminist ways, let's put it that way. I became a real feminist during these cases. But I knew that when we were selecting the jury, I could not ask the questions of those jurors as to those words that Erica used on the tapes, that if I said them, it would make it much too obvious. So for the 2 years before we actually got to having Erica on the witness stand, I would spend every morning looking in my mirror in the bathroom in New Haven there and practicing saying words that I had never used in my life before, but I finally got to the point where I could say with relative equanimity, motherfucker and motherfucking and a few others of that sort. But the deal was on the juror questions, Charlie always asked those questions. And by the time we got to the trial, when I had Erica on the stand and I was examining her, and after I'd finished, sat down at recess or something, and Charlie looked at me and said, "You actually said it."
Now, in talking to you about these cases, I remember you indicating that various comments Erica made to you had a profound effect on you in sort of an awakening on your part of certain key issues for women.
Sure.
Can you describe?
Well, actually, it wasn't just Erica. There was a confluence. Just before we began that trial, or maybe, and not trial, but before that first day in the courtroom that I mentioned earlier, when she just looked around and said, "My God," and I suddenly realized that I was, I had so accepted that the courtroom was a man's world that I'd forgotten it. But everyone was male. The judge was a man, the clerks were men, the stenographers, court stenographers were men, the sheriffs and the police officers who were around were all male, and all the other lawyers were men.
That sort of staggered Erica as she walked into the court and sort
Yeah.
of...
And when she saw it, she remarked on it, and I realized that that's where I'd been functioning for 20 years, and and I had forgotten just what a stark world it was. And then we went from there to other things. But at the same time, I had gone to a National Lawyers Guild meeting in Washington. And at that meeting, they had a women's caucus. It was the first time they'd ever done it. This is right at the early part of the women's movement, the Renaissance. And it was really what used to be known in those days as a consciousness-raising session. And here were a number of young women lawyers and others. And there were 4 of us older women there, one of whom participated in the panel at this caucus. But everyone was engaged in what was really consciousness-raising. And they were talking about their experiences in this male world and how do you deal with it. And I remember it as one of the most painful experiences for me because they were forcing me to look at myself as to who I'd become during that period and how much I had accepted various things in the courtroom and, you know, the role of women, and not only in the courtroom, but sometimes just outside the courtroom. And I remember going through this and really sort of forcing myself to stay. 2 other women of my generation at that, who were sitting near me at the meeting, left while it was going on, and I knew why they left. I mean, they just couldn't take it.
It had become painful for them to acknowledge what they had accepted.
Yeah, and they were rejecting in a way, too. The woman who was part of the panel talked about things such as she had been in practice with her husband for all these years. I mean, she was about my age, so it would have been about 20 years, you see. She did, I think it was workman's compensation or some sort of labor law stuff. And she talked about how she had accepted her role as second in the firm and this, that. And so I had that too while I'm dealing with representing Erica, which was a totally different experience than representing, you know, a woman in a divorce case or something. Here you were, in the divorce case, you're trying to make the court understand what the role of women is and just what their position is. But to explain someone like an Erica Huggins to that courtroom, which is really what you do when you defend someone.
Did Erica herself make any comments about being judged by men?
Well, actually, by the end of the case, you know, we had gone through things. In essence, what the defense was, although she had been living in that house, she engaged in that interrogation, but she had the defense really was that as a woman, she had no say over what happened. It was a very subtle sort of defense. And we didn't talk about it in those terms, but it was really what we were leading up to. And it was only when she was on the witness stand at the end of the trial that, and oh, I should say we had on the jury, there were, I think, 4 women we'd finally gotten. And when she was on the witness stand, I had put in her testimony. Now, one of her experiences, which I brushed on because when John had been murdered out in California, the police had raided that Panther house and taken everybody down. They actually searched her baby, this 3 or 4 week old baby, and took the diapers off to see if they had a gun hidden, or God knows what they were looking for. But anyway, they actually searched that baby as part of the thing. In point of fact, Erica had told me that when they went down to police station, Erica was arrested on a charge of, you know, it was in connection with the murder of John, as were several others who were at the house. And they booked that baby.
They booked the baby.
Yes. Now, I mean, that's what Erica had told me. I was presenting evidence, and I'm talking about Erica's background, because part of it is, what her feelings about the police were, especially after that experience. I asked if she had, when they came to the house, what happened, and she said she was arrested. And I said, were you arrested or something? And the judge said, Miss Roraback, come to the bench. So I went up with Arnold Markle, who was the prosecutor, and the judge said, I don't want you introducing the arrest of that baby. And I said, I would never have thought of it, and literally I never had, because no jury would have believed it. It had nothing to do with the case, and it certainly was some, but that I always was curious, and I thought, I was hearing things almost. Stan Simon, who was the reporter for the Hartford Courant, who was sitting there in the courtroom, and he had some sharp ears, I guess, because he asked me if the judge had actually said it. It never appeared in the transcript.
Interesting. Now, you had indicated.
Yes, I'm going to go on. Now, that's background, because then you see Erica's on the stand and she's talking about some of these experiences. Eventually, and we talked about the fact that Rackley was taken out of the house, etc. And the weekend before Rackley was killed, Bobby Seale had been in New Haven and had been at the house. That's how they were trying to tie him into the case. The Arnold Markle, in cross-examining her, said, with his usual sneering style, you were there in New Haven. You knew what was happening. Why didn't you do something? And she said, I tried. And he said, well, did you talk to the Huggins family, who you saw every day? And she explained to him that it's just not the sort of thing you talk to your in-laws about. And then he said, well, did you call the police? And that was one reason I put this other stuff in. She said, well, she didn't really think the police were interested, to put it mildly. And then she said, and he said, well, why didn't you talk to Bobby Seale when he was there? And she said, I tried. And he said, what do you mean you tried? At first he said, where were you? And we were sitting at breakfast in the kitchen of a house. We were having breakfast with some friends. And he said, what did you say? And she said, Chairman Bobby, there's a brother at the house. And she stopped. And he said, well, what else did you say? And she said, well, Bobby Seale turned away and started talking to someone else. And he said, well, what, and he kept at her, why didn't you say something to him? What? And she said, finally said, Mr. Markle, you have to understand, sometimes it's very hard for a woman to be heard by a man.
How did that resonate through the courtroom?
I thought the women on the jury, other than one of them, but three of them, were just going to hop out of the jury box and hug me. I mean, they could, it was one of the most dramatic moments I've ever had in a case. And Arnold Markle never heard it. He asked the question again. And Charlie Gary didn't say a word. Bobby Seale said, isn't that just like me?
Now, you had indicated that the Black Panther case, working with Erica, the Women's Caucus, as you just described, led to sort of a reawakening on your part of your role as a woman in law.
Yeah.
Can you describe that a little more in referencing? Now, I know also around this time, or even a little earlier, you were one of the few women, if I'm correct, that went to Mississippi.
That's right.
During a lot of the civil rights
Yeah.
issues there. Can you kind of describe that and then take us into Wounded Knee?
Well, interestingly, I was one of the few women. There were a couple of others that I got to know down there, but I was the only woman from Connecticut that went down out of about 30 lawyers. We were handling cases involving people who were trying to register to vote, and there were sort of things like, you name it, having a lapsed license on your car, or anything else they could find. And the technique was, because the Mississippi courts weren't going to pay any attention to a defense of these cases, and was to have them removed to federal court under an old statute that dated from the Civil War days.
Now, was this around the same time those 3 civil rights workers were murdered?
Just after that. I was in Mississippi a month after that happened.
Now, you describe your awakening as a woman and sort of faulting yourself for accepting so much of the male-dominated aspects of the profession. Yet here you are, a woman, going down to Mississippi in an area that obviously was dangerous. Did you give any thought to being a woman, or did you just look at yourself as a lawyer going to help?
I guess both. I mean, I was a woman. I didn't know that. The two things are sort of interesting. Number one, in federal court in Oxford, Mississippi, either the U.S. attorney or the assistant U.S. attorney who was there, I'm not sure, I know was a woman. Something that there wasn't a woman in any sort of role in Connecticut in any court at that point. So that was sort of an interesting thing. Interesting also was the fact that we were waiting to see the judge and sat in a courtroom watching a trial going on. There was one Negro juror who sat in the seat for alternates because he didn't sit with the rest of the jury, even though he was part of the 12-member panel. When they went for recess, he did not go to the jury room. The other 11 did. And, that was Mississippi. So there was these startling contrasts of the two things. I could also say that the one time I remember we went to a jail in Clarksdale to see someone who was being held in jail for having sold a bale of hay out from under a landlord's lien. And we went into that jail, and it was one of the scarier moments. While it was, a caricature of a policeman or jailer sitting there, pot-bellied, a can of beer on the desk, guns, etc. And we were supposed to confer with this guy who was standing at on the other side of the wall. So we told him that we were going to file a petition and we'd see him in court on Monday or something. As we're walking out, the jailer said, "Where are you going?" And we looked at him, and he said, first he said, "We knew you were coming because we knew about the car when you passed the town line," you say. And then he said, "You better not go to the Kofo house," which was I don't know, you better not, but he said, "Are you going to be leaving or are you going to the Kofo house?" And And then he just said, "You just be careful." And we walked out the door, and I must say, walking across that stretch of what was just hard dirt with a little tuft of grass here or there for about 100, or maybe it was 100, it was several hundred feet, maybe 1,000, to our car, and got into it. Now, I was with two men, and I'm sitting between them in the front seat of this car, and they said, "Where should we go?" And, you know, and I finally said, "Well, if you're asking me where I'd like to go, I think I'd like to get out of town." And, but you had to, when you walked that, you never knew what was going to happen in back of you. You know. Those
That
two men were
subtle
so
pressure of
relieved
fear,
I took
yeah.
them off the hook, because they didn't want to say it, but they wanted to go as much as I did.
Now, Catherine, talking about your evolution to a more activist role in women's issues certainly leads us into a variety of other cases, but I would hope we'd be able to talk about Wounded Knee, the Sachs case.
I want to, before we do, there was one that I didn't talk about, and that was that after Griswold, I mean, that's when the women's movement was really beginning to get going in the late 60s. We did a series of abortion cases in Connecticut to knock out the abortion statutes. And and in those cases, I think that's when actually, we filed those cases when I was trying Erica's case. Because I remember Charlie Gary couldn't understand that I wasn't going to be at the press conference when we filed the cases, because I was in the middle of a trial, and he said, "Well, we could get that postponed, you know." He couldn't understand not getting his face in the paper, which is typical of a good deal of the trial bar, I think. Anyway, those cases were unique in the way we did them. We did, it was known locally, not by the technical legal name of the case, which was Abele versus Markle, but it was Women versus Connecticut. Mm-hmm. And 100, or 1,000, I think it was 1,850 women became plaintiffs in that case. And instead of asking for a class action, we just had all these women as plaintiffs.
Individual plaintiffs?
What?
As individual plaintiffs?
That was my idea. I'd like to claim credit for it. And when we went to court, in those days, the anti-abortion groups, the Right to Life group, were primarily male, and they were all men, at least the ones that showed up in court. So that the day that a trial began, you see, or the pretrial motions or whatever, you'd walk into the courtroom, and here were all these, and I always like to have my clients in court when I'm trying cases. I think it's appropriate, even if they don't technically have to be there. So this huge group of women on one side of the courtroom, and a couple of men on the other. It looked like a wedding or something. Friends of the bride and friends of the groom. Anyway, only women plaintiffs, only women lawyers. There were several of my good friends who were quite upset that they couldn't join as attorneys on the cases, but we had a rule it'd be only women lawyers, women witnesses, and it really vividly drew out what a right to an abortion meant for a woman in those days. I mean, this is back in the days of the coat hanger and
backroom coat hangers.
and all of the worst things in the world. When I was doing the Griswold case, I would frequently have, maybe once a month or something, calls from people who wanted to know how to get an abortion. You know, did I know? Because I obviously knew the medical fraternity by that time. But the thing that really shocked me was one day a lawyer, Earl Williams, called me and said he had a client who was, I think it was Earl, was being held at the New Haven jail. She had gone into the Yale New Haven emergency room with the complications from one of these self-induced abortions. And when she left, when she was being discharged from the hospital, she was arrested for having induced an abortion on herself. And that was when I discovered that there was a rule at Yale New Haven Hospital that if a woman came in that condition, that they were to notify the police. And the police would come down and arrest them when they left.
And the hospital was following that rule?
Yeah, it was a hospital rule. I remember I called up Lee Buxton and said, Lee, and I told him what had happened. And he just, you know, he was gasping. He couldn't believe it. He said, I'll call you back. And it was, I don't think it was more than 15 minutes. He came, got back on the phone and said, there used to be such a rule. There is no more, period. But that was the way things were treated
handled
those
at that
days.
time. Can you talk about, you know, briefly Wounded Knee and the Sachs case?
Yeah. Wounded Knee was, this is out in South Dakota, an Indian reservation where the American Indian movement was very strong. And one day the leaders of the American Indian movement had taken possession or taken over the store on the reservation, and which is sort of like a company store. There was and then a series of people were arrested. I mean, numbers of cases, and a committee was formed to get lawyers to go out and represent these people. There were charges in federal court since it was a violation of some regulations of the reservation. And a person who was running the committee, a woman, called me. She had been an employee of trial lawyers, and she wanted to know if I would come represent some client of theirs. They wanted to have a woman there to represent some of the women who were being arrested. So I went out to, and trial was in the federal court in Lincoln, Nebraska. I went to Lincoln, and the woman who I represented had a son who was about 8 years old. And she also had a little baby. I guess she had several children. But the son had hurt his leg, and she had to get him to a doctor. And she had gotten into her car. It was about an 18-mile drive to get to the health clinic or whatever that she was going to go to. And she had gone to the company store to get gas for the car. And somebody came out and filled up the tank, and he said, he said, well, there's no charge. We've just taken possession of the store. Do you want something? You know, it's yours. So she walked in with her son and with her sister-in-law who'd come along from the ride, and several others who were in the car. And they just took stuff from this company store, get back in the car, and they go back to the house or their compound, And as I only have a verbal picture of this, but there were apparently several different huts or whatever, and one central one where there was a kitchen area. And they go into this kitchen area, and when they drove up the road to this area, it turns out it was private property. I never knew this about reservations, but their part of the reservation was theirs. And the police, the sheriffs followed them in, you see, or whoever they were, the police, and drive up, and they'd gone into this main hut, and her father was working on a truck that had broken down. He was underneath it, and these federal agents go and kick him and say, "Get out of there, come in the house," and forced him into the house. And so he's in the house, and they start looking for all this stuff that was bought. And they took into possession, there were some spices, I remember, some salt, Pampers, there's a toy truck or something that this boy had taken, and she had bought a package of candy which had been on the counter, and the grandmother was taking care of this baby who was on, it was on a central table. I said something about the sink because they said she was washing dishes, and my client corrected it because they obviously just pumped the water into a tub that they would put on this central table. Anyway, the baby was there on the table next to this tub where she'd been doing the dishes, and the baby began to cry with all this commotion. And so she'd opened the candy and stuffed the candy in the baby's mouth. And when the police came in, they seized everything, including the candy, and so I had a motion to suppress hearing. And it was always one of my favorite cases because I went through I made them mark in evidence every single thing they took from that house, you see. And there must have been 20 or 30 different items they'd taken, including this toy truck, and they produced this bag of candy, which was open, and I said, "Well, did you take, and was there any other candy that you seized?" To this officer who's on the witness stand. And he said, "Yes." And I said, "And where did you take it from?" And he looked, he was looking very upset. And the prosecutor, who was a relatively normal person, he sort of turned around and he looked at me, his back to the judge, but he said, "Not the baby's mouth." And I said, "Yes." and he just grimaced, and then this guy had to testify that he'd taken candy from a baby's mouth as part of this raid. Anyway, we got the case tossed out on the basis of an illegal seizure, but it was a lot of fun.
How long were you involved in the Wounded Knee cases?
Oh, that was just a few days, because it happened on the preliminary. Actually, I had come home in between because we first had selected a jury, and that jury selection was fascinating in terms of, I think, far worse prejudice on the part of the people of South Dakota toward Indians than anything I ever saw as to blacks in New England. I mean, it was just unbelievably harsh and deep.
Not meaning to push you along, but wanting to cover a couple of other cases, such as the Sachs case and then briefly the Peter Riley case.
Yeah. Well, the Sachs case was a woman who had was part of the sort of the far left student groups, such as Kathy Boudin, etc. She was a woman who had participated in it lived in Boston originally, she and this friend had participated in a robbery, but the robbery itself was committed by a couple of men who were in fact gangsters, but they were going to liberate this money from the bank to do good things, supposedly, and in the course of it, a police officer was shot and killed, and so she was charged with murder in Boston. And then she went, but she had left immediately after this occurred, and she and this friend had gone underground. They actually stayed in New Haven for a time, and there was a grand jury investigation in New Haven years later trying to find out, who knew whom. But she was eventually found and arrested in Philadelphia, where she got involved in another robbery case. But she was, she, in addition to being this, someone whose politics we would not necessarily agree with, to put it mildly, she was a real feminist. And when I first went to see her, she had asked, I know, her family, after she disappeared, her family had hired a very famous Boston law firm to represent her and to try to take care of things in her. It was Ropes and Gray. And when she was finally discovered, and the family just assumed that Ropes and Gray would be representing her, but she said she wanted to have me as an attorney, so I went to see her in Philadelphia, where she was being held, and I remember saying to her, I don't know whether you know who I am. And she said, "Oh, I was part of a demonstration in New Haven during the Panther cases." So that's the real tie-in to the Panthers. By this time, I mean, here you were trying to represent a woman. I was into a different mode than I had been with Erica's case, and indeed, it was it was not a case that you could win under any theory. To put it mildly, we did get a good outcome for it, but we did a series. In the federal court, you do. The judge does the questioning. You present potential questions to him. So we had prepared one of the most elaborate voir dires of a jury with suggestions of questions that would relate to women and so forth. It was really the best feminist document I ever participated in, I think. We never got to trial, so it never got utilized. But, and there was a suppression motion which was in itself fascinating, because after she and her friend had vacated their apartment in Boston, an aunt of the friend had gone to her parish priest to ask what she should do with some of the stuff she'd found in this apartment, which was pretty radical literature. And so he had referred her, and it was actually to a man who turns out to have been the CIA agent in charge of Boston. And this was another weird experience in court, when on the motion to suppress some of the stuff, I'm sitting there cross-examining the CIA agent supervisor of Boston, the Boston area, who was not supposed to exist under any theory of the law. And I remember just at one point, I was sitting there, and it was just such a surreal experience. I had obviously just stopped and was probably gaping, I'm not sure. And the judge said, "Do you have any other questions, Mr. Roraback?" I apparently just paused. It was
Catherine, before we go into the Riley case briefly, I would like to just bring out, you are still, the way I understand it, actively involved in practice
Yes,
in Canaan.
yeah.
And in fact, you,
Semi-retired.
and is it correct that you have weekly, not weekly, but monthly meetings of women attorneys?
No, yearly.
Oh, yearly meetings? Okay.
Yeah.
Of women attorneys
Yeah.
to gather and talk about problems and so forth?
Well,
and
just
different
smooth.
issues in the profession.
Yes.
Catherine, you mentioned your problem in stating certain words that Erica Huggins used. The Riley case had many ramifications, but interestingly, it had some ramifications for you for, again, using certain words. Not quite like what Erica used, am I correct?
Yes.
Can you tell us a little about the Riley case? And I know that's hard because there happened to be an editorial just in today's Hartford Courant
Oh, really?
about the Riley case and about him wanting to have the information
Yeah.
released.
No, I was the trial lawyer in the original trial of Peter Riley. And Peter was charged with killing his mother. Peter was a boy who was 18 years old. He had been raised by his mother. I don't think anyone knew exactly who the father was, except his mother, I suppose. And he came home one evening. By this time, he's 18. He had a car. He drove it home, and after being at a teenage center, and discovered his mother murdered. And it was one of the most brutal cases I ever remember seeing pictures of. I mean, it was nothing to look at Mr. Rackley's body, which a number of my co-counsel did not, I may say. When I looked at the pictures, they did not. The same thing would have been in spades in the Riley case, because Barbara Gibbons' throat was slashed from ear to ear. It was totally open. And gore was all over the place. I mean, it was the most bloody scene you can imagine. Although Peter was arrested within just a relatively short time of that murder, had not a sign of blood on him, was charged with the murder by the police after they questioned him at length. And not only, he came home, say, at about 9:30 or 10. He was taken to the barracks in Canaan. He was questioned at length. Then he was allowed to sleep in a bunk, and then they questioned him. I think they questioned him again in the morning, but they took him to Hartford and put him through a lie detector test, and during the course of that test and questioning, they got a confession out of him. In addition to everything else, Peter was not a tall man or a strong person. I mean, he looked like a callow youth. I didn't think physically he could have done that, but eventually the trial occurred. The confession was admitted to evidence, and he was convicted. One of the things that I was told after the trial, because most people who were around the courtroom thought I'd won it, he was going to be found not guilty. The court clerk, who was someone I'd known for years, told me that he thought that Peter made a terrible witness for himself. Now, when you try cases, you know that, here's a kid who came home, discovered that scene, was held at the Litchfield jail for, I would guess, a month or two before we could finally arrange bail for him, and had gone through that whole experience. And then when he finally came to trial in the spring, so that's say it was 6 to 8 months after it had happened, you, he isn't the same person he was when he walked into that door at home. And trying to reconstruct it. But Tony told me that he just didn't make a good witness. He couldn't recreate who he was, you know.
Now, during that trial, who was the judge?
Judge Speciale.
Was there an incident you had involving Judge Speciale where you were actually referred to the grievance committee, I believe?
Yes, well, there were several grievances. One thing that happened during the trial was that there was a day when he wished to have discussion of a plea bargain, and we spent the day. I had the Maddow family, who were friends who really took great care of Peter, came, and we sat there, and Judge Speciale was putting the pressure on to have a plea bargain, and I conveyed them to Peter. He absolutely said he hadn't done it, and he was not guilty. And Speciale kept trying to force me to get him to plead. You know, it would be better than, they were offering him 15 years, which is, as I remember it, I may be wrong about that. But he would not plead, and I refused to put pressure on him. And you know, as a matter of, to me, it's shocking that a lawyer would be expected to compel some kid to say he murdered his mother and have to live with that for the rest of his life. And I just, as a person, I could not do it, and I refused to put that kind of pressure on. Speciale kept telling me I was doing my client a disservice, I may say, because of my attitude. Then after that, the jury came in. It was a guilty verdict. The judge refused to continue bond. By this time, Peter had been out on bond. Refused to continue bond and set a higher bond that he wanted, a cash bond, to be posted, which was totally impossible. And so he was going to be going off to prison, and I was trying to keep as much time as possible before he went, trying to arrange something. And so it was pretty much all day that we were there at the courthouse. Joe O'Brien, who was the reporter, I think, for the Current, came up and kept coming up to me that day asking for comment. And I just refused to make any comment on the case. And this went on, I suppose, 3, 4, or 5 times. And when I'm leaving the courtroom, Joe said to me, "Any comment?" And I said, leaving the courthouse, Peter had just been taken off in the paddy wagon. I said, "No goddamn comment." And he printed it as in quotes. And so after the case was completed, Speciale had the state's attorney file a grievance against me. One of the things was that I had talked to the press too freely early on and commented about Barbara Gibbons, whom I thought was a very interesting woman. Secondly, he had a grievance that I had attempted to influence the court by having people in Canaan send letters and a petition to the court to free Peter. And thirdly, was the fact that I'd said no goddamn comment to the press. Charges which I'm glad were dismissed, may I say.
I was going to ask you, they were dismissed by the grievance committee.
Yep.
Catherine, in looking back on your career, was there any one defining moment or any one thing that had a significant impact on you?
I don't think so. I think it was just a series of here, there, and everywhere. One thing I hadn't mentioned was Ted Koskoff was head of ATLA just before, during the period of the Panther cases, and afterwards he arranged for them to do a panel on women trial lawyers, because at that point there were a couple of women who, well, there were women from all over the country, but ATLA didn't really recognize them, and so Ted wanted to have that, and so he had me invited. I had to explain to the president of ATLA that women trial lawyers didn't make as much as men trial lawyers, so I couldn't afford a trip to Las Vegas, which was involved. And they finally paid my expenses, and I did go to Las Vegas and spoke on this panel, and I remember then the pleasure I had at quoting from the books that were then in vogue to train lawyers as to how to treat women in the courtroom. I mean, these were trial practice books, the sorts of things. How do you do a cross-examination? How do you select juries? And there were always these quotes about how you treated women who might be on a jury or a witness. You shouldn't get them to cry, don't be too bullying, but then you have to be sure how you dress. I mean, and I stood there reading it to the author of one of these books. It was one of my great moments in time, was to be able to
stand there and address all the males.
He left I may say he left that session.
Catherine, if you were to be able to speak to women attorneys in practice today or women contemplating entering practice today, is there any specific advice you would give them?
Well, their experience is much different than what mine was, but certainly one of the things that I do worry about is that they will do the same thing I did, perhaps in a different way, of sort of accommodating themselves to the fact that the judicial system, in the way trials are run and personnel, et cetera, is still primarily a male field and a male-dominated way, and that you don't accommodate yourself too much to that fact of life, but in fact maintain your femininity and your awareness of the needs of women in that courtroom scene, and also force the courts to do a little consciousness raising with each trial.
Well, Catherine, I think the bar in this state has been benefited immensely by having you as an active and practicing member. And certainly your involvement in critical cases and critical issues of our time serve as an example, I think, to all members of the bar that law is a service profession, and that we have a unique obligation and opportunity to serve people and help people in our society. Certainly your, I think, career is one of excellence, and I think it's something we should all look at and try to emulate. And I just thank you for giving me the opportunity to interview you and work with you.
That's very kind, Howie. It's very nice to be here and to be interviewed by you.
Thank you.